Good morning. This is Judge Daniel Ramsek, Second Judicial District Court, Division 6. The court is calling the 10 a.m. matter of Toby Keeton versus New Mexico Racing Commission et al. Could I have appearances for the plaintiff, please?
Joseph DeAngelis for plaintiff.
Mr. DeAngelis, good morning. Do we have anyone else here for the plaintiff?
Good morning, Your Honor. Billy Blackburn, local counsel for the plaintiff, Your Honor.
Yeah, Mr. Blackburn, good morning.
Good morning,
And
Judge.
who do we have here for the defense?
Good morning, Your Honor. Eric Lohman on behalf of the Racing Commission.
Yeah, Mr. Lohman, good morning. All right. See various other people, but I think we have are there any other legal counsel present for this matter? Okay.
None for the defendants.
Okay. So we're here for a status conference, and I was reviewing the plaintiff's bench brief for the status conference. Plaintiffs say, first of all, the court has to address the presentment of the order on plaintiff's first motion for a preliminary injunction, which is court entered. That order has already been filed, so that is moot. The second issue was the protective order for third-party discovery. I understand that the parties have stipulated to an order. If you will get it to me, I will sign it. The third issue was response dates and a hearing on plaintiff's second motion for a preliminary injunction. We'll get to that in a minute. And the fourth issue was plaintiff's express reservations of objection if plaintiff is compelled to use the Pennsylvania laboratory. Without any assurance, the laboratory is independent and without being provided three choices of split laboratories. So for the record, plaintiff's reservations of objection, as I just read, because a brief was filed, your objections are noted for the record. So that's taken care of. So the only issue left for this status conference is to go to that second preliminary injunction. And in the order that I entered June 4th, I said within 10 days of this order and following collaboration between the parties on a list of agreeable laboratories, the Racing Commission shall provide a list of approved laboratories to conduct split sample testing. Plaintiff would identify his first, second, and third choice of laboratory, and within 7 days of plaintiff's selection of a split laboratory, the Racing Commission should send the split sample for testing. If I understand correctly, and Mr. Lohman, will start with you, if I understand correctly, the only laboratory that was identified was a laboratory in Pennsylvania. I could be wrong. Mr. Lohman, is that correct or incorrect?
Well, Your Honor, before I answer that question, the order that was entered on June 4th following the first hearing, that was not approved by the Racing Commission. The plaintiff submitted it directly to the court without I got it at the same time.
Did you guys each did each of you submit a proposed order?
Yes, Your Honor. I emailed your chambers. I emailed your chambers explaining that that order that was entered was not approved by the parties.
Oh, no, I understood. You guys had each submitted your own form of order, and that's the one I chose.
No, Your Honor. The order that was entered before I had the opportunity to present an order or provide any comment. The first time I saw that order was when the plaintiff emailed it to your chambers for execution.
Okay.
And so there was a back and forth with your chambers, and I'm looking for that email now, but there was a back and forth with your
answer me this. Did you provide, and we can go ahead, we can enter an amended order, but I don't get off track. Did you provide to the defendants choices of a laboratory?
Well, Your Honor, that gets to the root of the problem with the first order that was entered, and it did not accurately reflect your rulings at the hearing, and I'd be happy to get into that. But what we were able to do was provide the Pennsylvania lab, which is approved by Racing Commission. After the hearing on June 2nd.
I don't need a lot of talking. I just need to know. It sounds like you're saying, first, the order that you entered, we disagree with. 2, it didn't reflect what you ordered at the hearing. And 3, we presented them with the choice of one laboratory. Is that correct?
well, two laboratories now, but one of them
Oh.
was UC Davis, and Your Honor made some findings related to that.
Right, we're not going to use that laboratory. That's
Right.
what's already been decided. So after the hearing, what you suggested to them was this Pennsylvania laboratory. Is that correct? Is that the only one that was provided?
The Pennsylvania lab accepted the split sample, yes, the testing of the split samples.
Okay, got it. And and this is the lab that says it's going to take up to 6 months to test. Is that correct?
That was the estimated turnaround time, yes.
Okay, got it. And then let me go to Mr. DeAngelis. Aside from the 6 months that it's going to take, did you have any objection to this lab doing the testing?
We asked them to make some assurances that there was some degree of independence with the Pennsylvania laboratory. Our concern is that I believe it was our Exhibit 19 to the motion. There was an email circulated
Keep
among.
it really brief,
Yeah.
Counsel. What I'm asking you is,
Yes, we do have.
are you objecting to the Pennsylvania lab doing the analysis, setting aside the 6 months issue?
Yes, we have concerns that they're not independent, and so we asked for some inquiry into that, but we did not
All
receive
right.
any answer.
Okay, got it. So you had some concerns. You haven't heard anything back. Did you come up with any laboratories yourself?
We offered a laboratory at UCLA. We offered New York, and we offered one. I believe it was in Chicago.
Okay, so you made 3 proposals, and Mr. Lohman, what was your client's reaction? This is ridiculous. You guys should be able to agree upon a lab without all of this nonsense before this court. Okay, seriously. So, Mr. Lohman, what's the problem with the 3 labs that they recommended? You guys,
No, I don't.
You guys
Well, first,
can't agree upon a lab?
I'm not sure those labs were proposed by the plaintiff, but those are not, Judge, this idea that there are dozens or even thousands of labs that are available and qualified, and if there were that many labs able to do this work, we wouldn't have these backlogs. There are only a handful of labs that can do
Okay,
these.
but now you're going off track again. So you're saying, no, we didn't get the names of the 3 labs from them.
I don't recall. I don't recall those being proposed.
Okay.
In writing anyway. We had a phone call where there were a lot of names thrown out. I don't recall there being anything.
All right, so got it. I understand. So we're going to take this step at a time. What about the order that was entered on June 4th by this court? I understand you're saying it wasn't a matter of presentment of orders. We didn't even get a chance to submit our order. What is wrong, in your opinion, with the June 4th order which this court entered?
Thank you, Your Honor. So first, it requires that the way this order was drafted, it included a lot of superfluous findings. The court was very clear, and Your Honor must have said it. I could point you to the page and lines in the transcript, but the court said over and over again, for example, page 8 of the transcript, this court will approve a preliminary injunction, essentially ordering what the Racing Commission is agreeing to, that the sample will not be sent to any lab without further notice. Further down that page, I think a preliminary injunction is important at this point, is necessary.
Okay, but you're reading back to me what I said. What is it that you object to in the order? Well, you're saying that one full paragraph talking about administrative remedies, and all, you're saying that's superfluous and should not have been part of the order.
Well, so I can zero in on the areas that are either superfluous or were not what the court ordered. So first, in the first full paragraph, let's see, third sentence, plaintiff is entitled.
Why don't we do this? Why don't you submit your? I'm not going to go through the drafting order right now. Let me get back here. Here's what I have. I have. I
submitted a proposed order that tracked what the court ruled, which was just that we're going to maintain the status quo. The court said several times, I can point you to the transcript where court says that the only thing this injunction is going to do is to keep that sample where it is.
Right.
And that's it. There was no order.
Go ahead and submit your proposed order.
I have submitted a proposed order, Your Honor. It was emailed to Chambers.
Yeah, I sure don't see it. Go ahead and submit it again. Here's what I have. I have the completion of briefing. What was the date of the hearing, Mr. Lohman? Do you know?
June 2nd.
June 2nd. Yep, I have that. And then I go audio log notes, order, granting plaintiff's motion. And then after that, request for hearing. Okay, so I don't have any of your paperwork. I don't know why that is. Maybe it didn't get filed. Go ahead and submit your proposed order and put amended order. And then what I'll do, Mr. DeAngelis and Mr. Lohman, is I will compare Mr. Lohman's proposed order with the order that's already entered. And if I think the amended order is appropriate, I'll sign off on it, and that will be entered. Run a copy, obviously, to opposing counsel. Now, let's get back to the issue at hand, and that is,
Your Honor,
I'm sorry.
well, I'm sorry. I hate to
No
interrupt
problem.
you, but on that, I just want to make sure that what's clear here is that the only thing the court ordered in that hearing was that we would keep the samples where they are and maintain the status quo. And what this order would require is that the Racing Commission now comes up with 3 new labs, not already on the approved list.
Oh,
3
no,
brand new labs.
I am ordering that. Okay?
Well,
because you guys submitted a lab that I know you disagree, and I respect it, but I think that there is a conflict there. They don't want to use that lab, and I remember your argument about there not being a whole lot of labs, but you will submit 3 labs. That's what I ordered.
well, I don't mean to re-argue the point, Your Honor. I'm not trying to re-argue the hearing. I'm just pointing out that is not what I read in the transcript from the hearing. Your ruling was very narrow.
Fair enough, but I do think you have to provide some choices to the plaintiff. And so that language will be part of the order. All right, and this is exactly what's in the order. You're enjoined from sending the split samples that I ordered that. There's no disagreement. Within 10 days, you'll provide a list of appropriate laboratories. I don't need your proposed amended order. No, at this point, that's what I'm entering in terms of the preliminary injunction. Okay, you do need to provide some choices. And so, how long? So you have submitted the Pennsylvania lab, and the plaintiff is saying, well, we don't like that lab because we asked for assurances and we didn't get it. I don't know if that's true or not, but I think you ought to consider 2 others. I'm not going to get pulled into this, you guys. You should be able to agree upon a lab. This is ridiculous.
And that was my understanding of the court's order, was that the only thing the injunction was going to do was keep those samples where they are. No one's going to send them to UC Davis. We agreed with that.
Now I'm adding whether you think it was part of my original order or not, now it is. Okay, so the parties will discuss, they will collaborate. God, look at all the time that's wasted. That was June 4th. Now we're on July 7th, and this idea of collaboration hasn't occurred. And both parties are saying, well, I didn't hear anything, or I didn't get anything. So within 10 days of today, you can file, Mr. DeAngelis, I think you should submit an amended order indicating that we had a hearing today, and that the 10 days in the original June 4th order is extended out 10 days from today. And I think you guys need to collaborate and come up with a lab that you can agree upon. The plaintiff is complaining about the delay. Plaintiff, you're contributing to the delay, and the defendant surely isn't helping matters. So what we're going to do, and we don't even need an amended order. I'm going to stand by this order that is part of the record. Because the intent was that the parties were to come to some agreement as to an acceptable lab. I don't think that there's any confusion about that. And so what I'll do orally is that 10-day deadline in the June 4th order is extended 10 days from today. And I expect the parties to collaborate and come to a lab they can agree upon. And then, as the order says, if the parties are unable to come to an agreement, the parties may seek further relief, and then I'll pick a lab. I'll just pick one, ones that you guys are discussing. So I strongly suggest that you guys collaborate and agree upon a lab within 10 days from today. Then on the motion for the second permanent injunction, Mr. Lohman, you and your client obviously have to respond to that, but the issue is really one of time. And I think it's ridiculous that plaintiff be suspended from whatever it is they're being suspended from doing for 6 months because the lab that your client has chosen can't get to it for 6 months. Okay, that's ridiculous. We can't take somebody's right to make a living away from them for this long period of time simply because the lab you chose can't get to it. So the injunction, it seems to me, the second motion seems to me would take care of itself if you guys can find a lab that can get the results sooner. But barring that, and based upon what's happened to date, I'm not at all optimistic that you guys are going to agree to anything. Mr. Lohman, how much time do you want to respond to this second motion?
Your Honor, I intended on filing it in the next day or so.
Okay.
It was filed on the 17th. I didn't get it until the 20th. So the deadline would be, I think, Thursday, but I plan on getting it in before that.
What essentially is your response to their concern that this enforcement taken by the Racing Commission essentially is depriving them of their rights for at least 6 months?
It will be articulated in the response, of course, but a lot of this delay is on the plaintiff. It was nearly a month ago that the Pennsylvania lab accepted the assignment. And we would be a month closer to getting that result if they had agreed to. In fact, we had some email back and forth where I thought we were very close to getting that sample sent to Pennsylvania. That's why I asked for the status conference. And the motion for preliminary injunction was, I received it after.
Can the Pennsylvania lab
summary
speed it up?
suspensions are, excuse me?
Can they speed it up, assuming that, and then the defendants are, this is just also premature, and I shouldn't have put you on the spot like that. So you're filing a response.
Absolutely. And I'll tell you that the Race Commission was prepared to provide a prompt disciplinary hearing. That's when the plaintiff filed this action. And so we've put a stay on that to maintain the status quo until we could hear from the court.
Really all the plaintiff is seeking is an independent testing of this split sample. You guys can't agree upon a lab. If you can agree upon a lab that will do the work sooner, this may take care of a lot of this. All right, so we have the pending second. So the order that I entered early in June, I'm going to stand by, and I think the Racing Commission has to provide some alternatives aside from the one lab that the court's not going to require the sampling to be done. That's the U Davis or whatever the name of it is. Then you have the Pennsylvania lab, so you would provide 2 more options, and I understand that there aren't that many labs. Then once you do that, then the plaintiff can choose one of those 3 labs, or it can come up with a lab of its own, assuming the Racing Commission agrees. All right, so that will take care of the sample testing. That's really what this case is about, in my opinion. Then I'll look forward to seeing the response to the second motion for an injunction, and hopefully that'll be moot if you guys can agree upon a lab. Mr. Lohman, do you have anything else at this time?
Well, I suppose we'll cross that bridge when we come to, Your Honor, but I'm wondering what happens if there are not 2 or 3 other labs that have the capability of testing for this particular chemical, this particular carmoterol.
I don't know. I can't rule in hypothetical, so I'll let you determine whether, if that's the case, that's the case.
Well, so my concern then is, Your Honor, is that we've been ordered to provide a list of 3 labs that can do this.
Right,
I don't know that
you can't do it if there are no other labs, and that's what you alert the court to.
And I don't want to be accused of defying a court order if these labs just don't exist because the court has ordered us to find 3 labs.
You just file a declaration saying just that. we try to comply with the court's order, but we can't find any other labs. And plaintiff, you're more than welcome to submit your own proposed labs that do this kind of analysis. I mean, I feel like we're way out in the weeds on this one. Okay, there was a substance that the Racing Commission believes that was illegal. Plaintiff is saying, no, that's not the case. And now the big argument is who's going to test this split sample? And we're just veering away from that. So you guys are going to have to figure out the solution. Mr. DeAngelis, is there anything you want to tell the court?
Just briefly, Your Honor, I just want to make it clear for the record that we've done everything we can to try to collaborate on a list of laboratories. We've just been stonewalled. I'm sure that'll work itself out in the briefing.
When you say stonewall, do you mean you've submitted proposed labs that the Racing Commission doesn't respond to?
Well, we had conversations about alternative laboratories, and the answer has always just been, well, we haven't approved additional laboratories, and we're not going to violate our own regulations. And so I'm
Are your proposed labs violating any regulations?
No. One of them, the New York one, is a racing laboratory. So we haven't had any kind of conversation about why the New Mexico Racing Commission won't accept them as an alternative laboratory.
Okay, why don't we do this then? You guys collaborate within the next 10 days. If you can't come up with the laboratory, then Mr. Lohman, you submit your proposed laboratory or laboratories, plural, same thing, Mr. DeAngelis, and I will pick one.
Perfect.
And we'll just get that because we need this analysis so the parties know where they stand. It could be that the split sample shows that the original findings that the Racing Commission relied upon are inaccurate or inconsistent. It could also be the split sample shows that what the Racing Commission believed to be true is in fact true and accurate. And once you guys have your answer, then you'll know where to go from here. But right now, it kind of boggles my mind that we can't get the testing done without all of this back and forth. And it's because I'm not in the middle of it. You guys are. You're probably going through a lot that I'm not understanding. But go ahead and collaborate. What we'll do on the motion for the second injunction, I will wait to get Mr. Lohman's response. So there's nothing to do on that right now. And then you guys collaborate on a potential testing laboratory. And if at the end of 10 days from today, so that would be July 17th, if you can't agree upon a lab, then each of you please submit, just indicate collaboration was unsuccessful. I, plaintiff, am submitting the proposed lab, proposed testing by these labs, and then Racing Commission, you do the same. And if you could include in your description or list of the labs a little bit of information about each one, I would appreciate it, including how long it would take them to get a testing done of the split sample. That will get, because if the plaintiff is proposing labs that are going to take up to 6 months as well. Okay, anything further, Mr. Lohman?
Your Honor, at the beginning, you mentioned it sounded like some written objections were entered or preservation of some written objections. I'm not sure I've seen. Can you tell me what,
I'm sorry,
what you're referring to?
Yeah, and I'll go through the list again. The presentment of order on plaintiff's first motion for preliminary injunction. I said I had entered that it was moot, but it wasn't because Mr. Lohman apparently had not stipulated to that order, and I did not have a copy of Mr. Lohman's order, so I do apologize for that. The entry of the protective order for third-party discovery, if the parties want to submit that, I'll sign it. The response dates in a hearing on the plaintiff's second motion for a preliminary injunction. We've already covered that. And then the fourth item simply was the plaintiff is saying, look, if the court forces us to use that Pennsylvania laboratory without any assurance that the laboratory is independent and without being provided additional choices, then we're stating our objection for the record. And what I see that by filing this bench brief, the objection is part of the record now.
I'm sorry, I see that. I thought you were referring to a separate filing that I had not seen, but we're on the same page now.
Okay, thank you, Mr. Lohman. Mr. DeAngelis, anything further that you can think of?
Nothing at this time, Your Honor.
Okay, listen, I know you guys are doing your best, and so I hope that you can work out something through a collaboration. If not, then I'll appoint a laboratory and we'll get this moving. So I do appreciate the work you guys are putting into this, and I appreciate you guys showing up today. You have a good day.
Thank you for your time, Judge.
Take
Thanks,
care.
Judge.
Thank you, Your Honor.
Have a good day, Judge.